Hi everyone, thanks for joining us for our April webinar. As a lot of you know, we're doing these webinars on a monthly basis as more of a educational purpose and just ways that we can stay in contact and stay in touch with everybody. So April's webinar is on estate planning. As a lot of you know, we have our objective is to provide comprehensive financial planning under one roof. So we're lucky enough today to have James Phelps with us. He's the owner of Phelps LeClaire Estate Planning. Before I get into that, my name's Scott Aitken. I'm an advisor with Wild Wealth. I'm out of our Tempe office. And I'll be hosting the webinar today. So a few quick housekeeping items. As a lot of you know, our firm really focuses on giving back to the community. Our second quarter charitable initiative is with Child Crisis Arizona. So if you want more info on that, feel free to go to our website, just wildwealthmanagement.com, and then go to the events page. There's some info on that. But basically, we're collecting items this quarter for underprivileged youth in Arizona. So again, feel free to contact our office directly or go to the website for more information. On the screen here, you can see some of our representatives in our Scottsdale office. I think if you join these webinars frequently, or if you've been a member or a client of our firm for a long time, you've noticed how quickly we've grown. So I feel like even though we're doing these every month, the list continues to get larger and larger. So that's great. We're excited to welcome some new people to the team. Here's some of our folks in our satellite offices. So you can see the Tempe office, the Glendale office, Tucson, Payson, and we actually now have an office in San Luis Obispo, California. So excited about the growth that our firm has seen. That's a testament to our clients. So we want to say thank you very much. I don't want to bore you too much with the housekeeping items, but again, James Phelps here. He's going to give a probably 20-30 minute presentation on estate planning basics. And we'll give you some info at the end of the webinar here if you need to contact his firm directly with any questions. So little background, I've known James now, we're probably coming up on about a decade. I've worked pretty closely with him and his team for many years. They do a phenomenal job, which is why we've never felt the need to pivot or change who we're working with. So James, directly thank you to you and your team for what you guys do. I know you help a ton of our clients and everyone's been very pleased and impressed with the service that you all provide. So thank you very much. So without further ado, James, take it away.
Very good. Thanks, Scott. Sure. Good to be with you and with everyone. Yes, Scott and I, like he says, have known each other for years, and it's always nice when I'm working with Scott's clients. They got everything teed up, everything's well organized. It makes our job so much easier. And so we really enjoy working with him and with his team. So yeah, really glad to be here. And my hope is just to give you a good overview of what estate planning is. I think when it comes to estate planning, the first step is to get educated. There are a lot of different options out there, a lot of different directions you can go. And so hopefully in these few minutes, I can give you at least some guidance of where to get started and really talk about what is estate planning at its core. Just a little background on me and the firm. So this is actually a picture of me and my dad. We are a multi-generational firm. I come from a family of estate planning attorneys, and this is, my dad was doing trusts and wills back in the early 80s is when he started doing it. And I was his assistant as a kid. I was typing up the wills and the trusts. So I got exposed to it at a young age, and eventually I followed in Dad's footsteps. And over the years, the firm has grown. So we're now known as Phelps LeClaire. So to my right there in the picture, that's my partner, Jeff LeClaire. He and I have worked together for many years. He's just a great partner, and we have a wonderful team around us. Kelly and Ryan are the other two attorneys, and I really enjoy the team that we have. And so we've been doing this now for over 40 years, and estate planning is really exclusively what we do. We don't do litigation or bankruptcy. We don't do divorces. We just focus on what we're best at with the estate planning. And we do all aspects of estate planning, really. We do both the front end planning, designing the trusts and the wills, but we also do the back end planning when we're actually helping the families administer the plans. And that's when we see what works in real life. It's one thing to have a set of documents, but I actually want those documents to work when the time comes. And so we do have that perspective of seeing these things work all the way through the end of the each stage of the process. And we do have degrees in accounting and tax law as well, which is important because estate planning and taxes go hand in hand. And we have offices located throughout Arizona. Some of those offices we actually office with Well Wealth. And so that's nice to have that partnership with them. So I know estate planning is just kind of one part of your picture, and it's an important part, but I always like to tell people, just know we don't do estate planning in a vacuum. I always want you to keep an eye on, how are you growing your wealth? How is your investment plan and your retirement plan looking? At the end of the day, estate planning doesn't do a whole lot of good if there's nothing left to pass on at the end of the day. And so that's why I always want you to work with Scott and somebody from his team, because they know what they're doing as far as growing your wealth and making sure that there's something to pass on. And they're the experts at that. We're not. We do the estate planning and they handle the investments. So I want to talk about the top estate planning mistakes to avoid. There's a lot in a few minutes here. We're not going to be able to cover all of them, but I want to cover at least the most common ones that we see. And so maybe I can get through 4 or 5 of them here in this presentation. But let me first talk about what is estate planning to make sure we're on the same page there. So estate planning, the way I see it, is we're really answering 2 basic questions. Okay, so the first question is, if something happens to you, then who's in charge, right? Who's in charge of your finances or your medical decisions if you're disabled? Or what if you pass away? When you pass away, who's going to get all your stuff? That's question number 2, is who gets your stuff, right? And so that's really what we're focused on, who's in charge and who gets your stuff when these times of disability and death happen in your life. And it can get very confusing. The questions are pretty simple, but the answers are not always very simple. And there's a lot of different laws that can come into play here. One set of laws is what we call the Arizona Probate Code here in Arizona. Okay, and so this is the book that we go to answer those 2 questions of who's in charge and who gets your stuff. And so there's a lot of pages there. So that in itself is confusing, but also depending on the types of assets you have. So if you have pensions or 401ks, we have to go to a different rule book that is actually governed under the federal laws. And that rule book is called ERISA. All right, ERISA stands for Every Ridiculous Idea Since Adam. Okay, it's a very complex set of rules that deals with, among other things, who's in charge and who gets your stuff when it comes to your pensions and your 401ks and other tax deferred assets. So the point is, these rule books are going to make it very confusing if we have to go to them. But my hope is that we don't go to the rule books, because you can plan around them. You can make your own decisions. And that's really what I want you to do. And that's what estate planning really is you taking control of the decisions. That way, when you pass away, then the rule books are not what's making the decisions for your family. It's going to be you who's made the decisions in advance. And you do that through proper estate planning. So that's really where we're going with today's presentation. Let me ask you a question. Any idea what percentage of people in Arizona have a will in place? Shot in the dark, I know, but it's actually 100%. Okay, 100% of people have a will. You might think you don't have a will if you haven't done it, but you actually do. When you came out of your mother's womb, you had a will. It was in that book I just showed you, in the Arizona Probate Code. They have a will for you. But the problem is it doesn't say what you want it to say. And so I would rather you do your own estate plan so that strangers are not making decisions for you and your family, but you're making those decisions yourself. So let's talk about mistake number 1, which is letting your family go to probate court. Probate court is something that's very, it's just very expensive, very time consuming. It's something that you want to avoid. And there's 2 types of probate. There's death probate, meaning when you pass away, your assets have to transfer to your loved ones. And that doesn't just happen automatically. That has to happen under the court's supervision if we don't plan right. And so that's when you pass away. But also while you're living, there might have to be probate too if you're disabled. If you're disabled, then the court would have to appoint a conservator to act in your behalf. And that's going to be another long, drawn-out court process, very expensive, to have doctors come in and testify and to have an attorney on retainer. It's something that you want to avoid. And so remember that in Arizona, where there's a will, there's probate. Having a will is not enough to avoid probate. And so for that reason, I don't do very many basic wills anymore, because if your assets are worth more than $75,000, that's going to be enough to put you into the court system when you pass away, or $100,000 for real estate. And so I'd rather you just avoid that whole process, because we could be looking at 2 or 3 years after you pass away, and a good chunk of your estate just getting wiped out by attorney's fees and court fees and CPA fees and all that's involved there. And it's it's a hard enough time on your family when these things come up, and I'd rather them not have to experience it in the court system. So how do we avoid probate? There's a couple simple alternatives first. That we call joint tenancy or beneficiary designations. This just could mean simply you have a joint owner on the title to your assets. That might avoid probate. Say you're married and maybe both of you are on the deed to the house or on the bank account. And so if one of you passes away, then it should automatically pass to the survivor. But that's not going to get you all the way there, of course, because eventually the second one passes away. And it's going to cause all sorts of problems if you add other people to your titles. I wouldn't recommend adding anybody to your titles like a child or a friend, because by doing that, you're exposing your assets to their liabilities. And that's going to be some exposure for you. You can name beneficiaries. This is a better option than joint tenancy. That just means each asset has a beneficiary designated of who it will go to upon your death. And you have to do this with each asset, with your bank accounts, with your real estate, your vehicles, your life insurance, IRAs. All those can have beneficiaries designated. If you do it properly, it will avoid probate. But it doesn't avoid all of the other issues that we'll talk about, things like disability planning. You have not planned for disability by naming beneficiaries. Also, you have no control over when the money goes to the beneficiaries. So if you have young children, or beneficiaries that are not good at handling money, you don't want to name them as beneficiaries, because if you do, when you pass away, they get all the money all at once, and that may not be what you want to happen with the inheritance. So these can avoid probate, but there are better ways. And I want to focus on the best way to avoid probate, which is the revocable living trust. We have done thousands of these over the years. This is our bread and butter. We have seen these work for over 40 years. They avoid probate, and they do so much more. So let me give you just a quick 101 on trusts. The terminology we use is the trustor. Okay, so this trust is really an agreement between 3 parties. And these 3 parties, we call them the trustor, which is you. Okay, that's the creator of the trust who sets up all the rules. And so you're the one that signs the trust and brings it into existence. And then we have the trustee. The trustee is the one that manages the assets that are in the trust. So if you had your house in your trust, which you would want, then your trustee can sell the house. Or if you have your bank account in the trustee is the one who can sign checks. And so I want you to be the trustee. That way you can maintain control over all your assets. And you can do this in a revocable living trust. You can name yourself as the trustee. And then you also get to name a successor trustee who steps in your shoes if you're ever not available because of either death or disability. So that successor trustee, you get to choose that person instead of the court choosing the person. And then the third party is the beneficiary. And the beneficiary is the one who gets to spend the money, right? And so I want that to be you as well. So you are the lifetime beneficiary. And then when you pass away, the beneficiary becomes your children or charities or friends, whoever you want it to be. That will all be spelled out inside the revocable living trust. So everything is planned ahead. And your successor trustee is just executing your instructions. It's really their only job. And so these are the 3 parties, okay? And you see the pattern is you are the trustor, the trustee, and the beneficiary, which is good news. That means that you just control everything. Nothing really changes during your lifetime. Now, there is one thing that is going to change, though. When we do the trust, the titles to your assets need to change. We call this funding the trust. And so when you create the trust, right, we have you come and sign it. That's step 1. But then step 2 is we need to transfer all these assets into the name of the trust. And we got to get them out of your name. So your house and your vehicles, your bank accounts, your life insurance, whatever assets you have, there's a couple exceptions, but for the most part, all of your assets need to be titled in the trust. And if you do that, then those assets don't have to go through probate. But if you leave them in your name, right, if you just do the trust and then you don't actually put the assets in the trust, then your trust is going to be empty. And so the assets still have to go through probate upon your death. So this is a very important step that we always want to help our clients with, because I see too often trusts get created but not funded. And so probate has to happen anyway. And so this leads us to mistake number 2, which is thinking that all living trusts are the same. All right, I've seen many trusts come across my desk over the years, and they can be very different. I like to compare it to a vehicle. All right, have you heard of the Yugo? The Yugo was called by Time magazine the Mona Lisa of all bad cars. Right? They said, the best thing about the Yugo was it had a rear window defroster. So when you have to get up to push it, your hands stay warm. All right. That's the best thing about the Yugo. But if we compare that to the Mercedes or to whatever your choice of car is, they're just not going to perform the same. Right? Once you pop open the engine, they're going to be much different. And that's very true with a trust as well. I'll give you just one example of how they're not all the same. What I mentioned before, actually not all trusts avoid probate, which is a shame because this is the main reason that people do a trust. But very many trusts go through probate because what I talked about before, the assets don't get into the trust. So you got to make sure when you do the trust, we get the assets in, and this is an ongoing process, right? Over time, you're going to get new assets. Now, as you do get new assets, if you do it right, you shouldn't have to go see your attorney every time you purchase a new car or you open a new bank account. You just need to make sure it's titled in the trust right off the bat. And so what we do for our clients is we give them, we call it a trust ID card that they just carry around with them, and they show it to the dealership, and then the dealership knows to put the vehicle in the trust, and same thing with the bank accounts. That way the assets are always in the trust as you acquire new things over time. And then you always want to just go visit with your attorney. We say about every 3 years. Make sure you have those checkups to make sure nothing is slipping through the cracks. That's very important. And so this is probably the big reason why I see plans go through probate, and why I would avoid do-it-yourself type planning. You can go on the internet, print off a generic form, and just fill in the blanks. Sometimes credit unions would do living trusts for you. And I think that's a bad idea. You should have an attorney, somebody who does this day in and out, do the trust for you. Whatever money you think you're saving on the front end, your family will pay many times that on the back end if you don't do it right. You got to get it done right the first time. And so I would recommend have the trust done right, and don't try to do it yourself. Let's go down to mistake number 3. This is failing to address what will happen if you're disabled. Right? Disability can be something that we don't want to think about, but it's important to take care of this possibility. I want to make sure that you don't have to go to court during this time. And so you should have 4 documents in place. And I'm just laying them out here for you on the screen. Okay, the first document is the living trust. The living trust allows your successor trustee to act for you if you're disabled without having to go to court. Also, you'd want a medical power of attorney. That's the document that says that who's going to make medical decisions for you if you can't do it yourself, along with a HIPAA authorization. And that says who can talk to my doctors and who can get copies of my medical records. And then the last one is your financial power of attorney, which is just a blanket power of attorney that says who can sign on your behalf during a time of disability. These 4 documents really work together, and they should be included in every estate plan. And that will cover any situation I can think of when it comes to having somebody act in your behalf if you're disabled. So you want to have those 4 documents in place. Now, mistake number 4 here is not protecting your beneficiaries from themselves. Okay, I don't know who your beneficiaries are, but I do want you to think, kind of fast forward into the future and say, okay, I've passed away. Now all of my assets are being liquidated. And it's just going to all go to my beneficiaries as a lump sum all at once. Will that be a good thing for them, or will it be a bad thing for them? And I don't know, but you need to think about that question. I like to say that an inheritance is like a brick. Okay, if I have a brick in my hands, I can use it to bash in a window, or I can use it to build an orphanage. Okay, the brick is amoral. It just depends on whose hands is it in. Well, an inheritance is the same way. If I have an inheritance in my hands, or if I pass it on to a child who's responsible, well, it will be a real blessing for them. It can improve their life. But if I put the inheritance in the hands of an irresponsible child who's not ready for it, then it's going to make their life even worse and make them even more irresponsible. Now, the nice thing about the trust is you can design it however you want to, so the money goes to the right people in the right way at the right time. So if you have, for example, young beneficiaries, children, well, we don't want them to get the money when they turn age 18. We want them to maybe spread it out over time, right? And so you can set up the trust so the money is available for them in the discretion of your trustee while they're going through school and college. But maybe it's not until they reach certain ages that they get a check from the trust. So maybe they get a third at age 25, and then at age 30, then a final third at age 35, however you want to do it. The point is just spread it out for them so they don't blow all the money at once. Or if you have beneficiaries that have addictions, so that's going to be a real nightmare. If they inherit money, now you're just feeding the addiction. So every trust we do will have a clause saying that if we have beneficiaries with drugs or alcohol issues or gambling problems, they don't get the money right away. We can just feed it to them little by little as they need it to make sure that they have what they need to live or to get through rehab or whatever it might be. And probably the most common one is beneficiaries that are not good at managing money. If you have that child who you just see live from check to check, they don't know how to save money, that's not going to change when you die. It's going to get worse if you just give them a bunch of money. So for them, we can do what we call a spendthrift trust. It's just language we put in the trust that allows beneficiaries to receive the money little by little in the discretion of your trustee. And there's other circumstances we can talk about. Special needs beneficiaries is a big one. We want to make sure beneficiaries are not disqualified from their government benefits. The point is, though, that you want to keep the trust flexible so that when these situations come up, or as they come and go, both during your lifetime and after you pass away, your trust can adapt to these changing circumstances. And there's a real art to drafting the trust in a way that is flexible like this so that we can always make sure these situations are taken care of if they come up and then when they go away over time as well. Now, maybe you're saying, James, in my family, I've only got grade A beneficiaries, right? I don't have a bad kid in the bunch, so I'm just going to give them the money. And that's great. But I always like to emphasize with clients that it's not just protecting beneficiaries from themselves, it's also protecting them from third parties that might come in and try to take the money from them. So that's mistake number 5 here, right? Mistake number 5 is not protecting your beneficiaries from unknown third parties. And this is very important because I can tell you many horror stories of when a beneficiary received an inheritance and then there was a divorce. Maybe 5 years after the parents passed away, their child was in a divorce. Well, we're a community property state. And so that means that the money, if it's not handled properly and given to the child in the right way, well, if there's a divorce years down the road, half the inheritance is going to go to the ex-spouse. And that's probably not what you want to happen with your hard-earned money. And then we have creditors and lawsuits. I once had a situation where a daughter came in with a trust that her dad had done for her many years before. And dad had passed away and she was in the middle of a lawsuit. Well, she came to us with this trust and saying, if I lose the lawsuit, am I going to lose my inheritance too? Well, we looked at the trust and it was very typical. It said if she was over the age of 35, she gets the inheritance outright after her dad passes away. And so actually in that case, there was nothing we could do to protect her inheritance because it was outright distributions upon her death. She was over the age of 35 already when her dad died. So I want to design your trust so that these 3 unintended beneficiaries don't come in and grab the money from the people that you want to get it. So we don't want to do outright distributions. That's what causes the problem. And still, most trusts that I see coming from other places are still doing outright distributions. And this is the wrong way to do estate planning. There's a better way. That better way is what we call the protective inheritance trust. And the protective inheritance trust is essentially a protective wrapper that we put around the trust, right? So if I were to kind of show it to you visually, it's during your lifetime, you just have one trust with you or you and your spouse, you have a trust together. It's one single trust. But upon your death, we can design it so the trust doesn't just dissolve. Instead, it branches into separate trusts for each of your beneficiaries. So if you have 3 kids, we'll call them Bob, Jane, and Jim, they can each inherit money, not directly, but inside of a trust where the money stays safe for them. And because these are the good kids, they can each be trustee of their own trust. And that allows them to have full control and to take money out when they want to. But if they're not going to need it, they can keep the money in the trust where it's safe from all of these unintended beneficiaries. So let me do just a quick case study for you. So you see how this works in real life. Okay, so you want to give money to your son Bob, right? Well, you could give it to him directly. This is what most trusts do. He's over the age. He's responsible. He's an orthopedic surgeon. He's doing well. Well, but the problem is maybe he's got a high maintenance spouse. If you just give it to him outright, that money is going to end up in his joint bank account, and then she can start spending the money too. It becomes her money just as much as it is his money. And then because he's a surgeon, eventually he's going to get sued. Well, when that lawsuit comes around, if you gave it to him outright, well, we can't protect it. But instead, if you put it inside a protective trust and you make him the trustee of the trust, now he has the best of both worlds, where he has full control, but it's protected from his spouse, from a lawsuit. And so that way he can make sure the money goes where he wants to on his terms instead of on somebody else's terms. And then maybe you have a daughter, we'll call her Jane. Okay, Jane, wonderful girl, but she married this guy, right? And he's just a nightmare. He's just that in-law that we didn't want. But she married him anyway. And so he's irresponsible with money. And you just know when that money hits her joint account with her husband, it's going to just disappear. But instead, if you put it inside a protective trust, well, if that divorce happens, maybe 5 years after you pass away, it will still be her money. It does not become his money too. And so she can control it both during the marriage, and even if the marriage is dissolved down the road, it will still be her money, and it doesn't become part of the divorce proceeding. It's like a built-in prenup for your daughter, Jane. And then your son, Jim, okay, or Jim, he's just got every problem you can think of. He's got creditors, he's irresponsible with money. Well, him, you definitely don't want to give the money to him outright, because if you do, he's going to just blow it, or his creditors are going to get it. So instead, you put it inside this pit, right? This protective inheritance trust for him. That way, you can have somebody else be in charge of the money for Jim. Maybe it's your son Bob or somebody that you want to be in charge of the money. And that way, Jim can get the money when he's ready for it, and when his creditors are not working around the corner waiting to grab it from him. So really, all three of these kids, I think, are better off with the protective inheritance trust, right? And so this is why every trust we do has a protective inheritance trust built into it for each beneficiary. And so this is something that you would want to pay attention to. It's a very nice peace of mind, not just for you, but also for your beneficiaries, where they know that you gave the money to them in a vault, instead of just leaving it in the open for anybody to grab from them. And then you give them the key to the vault so they can open and close it at will. And that's a wonderful way to plan. I highly recommend you have this in your trust. So those are kind of some of the top mistakes that I see. I could list many more as well, but those hopefully have been helpful for you just to go through just the basics, the importance of avoiding probate, both upon your death and disability, making sure the money goes to the right people in the right way at the right time, and then also making sure that nobody comes in and grabs the money, a creditor or an ex-spouse after you pass away. Those would be some basics of estate planning. And maybe the biggest mistake is procrastination. It's so easy to put this off on the back burner. I know it's something that sometimes the discussions are hard to have, but I would say just do it. It's important to just take the steps to do it. But we're glad to help in any way we can. Scott, I think I'll turn it over to you. We're always glad to help your clients or anybody who's listening to this as we can with free consultations, or call me with questions. Glad to help out in that way.
James, thanks so much. And this is perfect. I was going to ask you how people could get a hold of you if they need to. So you can see on the screen now the phone number to James's office, and you can always contact myself or my firm as well, and we can get you in touch. Our firms, even though we are separate entities, we are strategic partners, so we work very, very closely with one another. James, thank you so much. I know that was a little bit of a condensed version of what you normally do, but you hit on some really great talking points. I'm sure there's going to be plenty of folks that watch this that are going to have some questions after listening to it and watching it. So please don't hesitate to reach out either to your existing advisor here at Wild Wealth or contact James's office directly. They'd be happy to set up a consultation with you. That being said, again, our objective here at Wild Wealth, we're looking to do these webinars monthly. So typically the last Wednesday of every month is when these air. Again, this is the April webinar, so you'll get some info about when it actually is going to air, and then just keep in touch or keep your ears open for what we have coming in the future. And again, thank you so much for your time. We appreciate it.